Good morning to everybody on the call. My name is Andrew Davidson. I'm the National Head of Employment, as Heather says. And this webinar really is a roundup of cases that we think are interesting from this year. And it's a relatively um, subjective assessment of cases in terms of their importance, but we've chosen them on the basis of cases which we think are interesting to our clients. And on that point, for those who don't know us particularly well, Hempsons act for a range of clients. On the employment side, we act for healthcare clients, social care clients, charity clients, education clients, private providers, private organisations, a whole range of employers. And so this session is really aimed at people that are likely to use our services and want to use our services. I'll remind you at the end, but if you are not already subscribed to our updates by email, please make sure you are, because we'll be talking about some of these cases as they progress and also developments generally in the field of employment law. We have a blog as well, and we are active on social media. So all of those links are at the end. But with no more chat from me, I'm going to talk about the areas I'm going to cover. So very broadly, three areas where I think there have been interesting cases this year: disability discrimination and reasonable adjustments, developments in whistleblowing and protected disclosures, and then finally the Equality Act and belief discrimination developments. And as I say, we could choose a variety of cases from 2024, all interesting, but these are the cases which we think are most important in terms of your practical knowledge and skills for HR and employers generally. So first, a few cases on disability discrimination, reasonable adjustments. And the first case is a case called Price against accountant in bankruptcy, which in reality is the Scottish Government. So Mr. Price was an administrative case officer, and he had a number of conditions: agoraphobia, claustrophobia, anxiety, and mysophobia, which is fear of germs. And partly because of the disabilities, but also because of lockdown, he'd worked from home since the lockdown in 2020. The Scottish Government had a policy that required all employees to come into work a minimum of 2 days a week. And because of his disability and because he wanted to remain working at home, he put in a flexible working request such that he would be able to work permanently from home as a reasonable adjustment. Well, the employer rejected that request, and it led Mr. Price to bring an employment tribunal claim. The tribunal, in considering his case, focused on the reasonableness of the adjustment. That was really their focus, because the employer had accepted that he was a disabled person under the Equality Act. They also accepted that requiring attendance at work was what lawyers call a PCP, provision, criterion, or practice. So there was a requirement to attend the office on all employees, and that was the PCP. The tribunal also accepted, and the employer accepted, that this put the claimant, because of his disability, at a substantial disadvantage, which is the next part of the test. And so the only issue really was whether or not the adjustment in itself of permanently working from home was reasonable. Tribunals can look at a number of factors when they assess the reasonableness of an adjustment, and I've put some of the main factors there. But the sorts of things that the tribunals will look at will be the effectiveness. Is this something that is going to minimise or reduce or eliminate the substantial disadvantage for the individual? Is it practical? How much would it cost? How much resource is it going to take up if you accept it? And then finally, the size and the nature of the business. So this is not an exhaustive list, but these are the factors which a tribunal will mainly take into account when they consider whether a particular adjustment is reasonable. And in this case, the tribunal upheld his claim and accepted that 100% home working was a reasonable adjustment. Now, it's an obvious point, but it's a point that's worth making. Of course, every case is determined on its own facts, and they had to look at the background in this particular case. There are a number of issues that the tribunal found persuasive. First of all, he had actually worked from home since 2020, and that had been effective. And so looking at appraisals, looking at his performance metrics, there was no reason to think that hadn't been an effective way of working. They also concluded that the issues raised by the employer in relation to his training, monitoring him, and engaging with stakeholders were overstated. So they accepted there were points, but they didn't think they were as important as the Scottish Government said they were. And overall, doing this balancing act, they concluded that the benefits to the employee of granting the adjustment outweighed any disruption to the employer. So what lessons can you take away from that? There are two in particular, I think. The first is that when you reject a reasonable an adjustment, particularly in relation to home working, you're going to have some pretty good objective reasons, business reasons, why you need somebody to come into the office or into their place of work. And the second issue, which is something we foresaw, employment lawyers foresaw would happen after the lockdown in particular, is looking at what in fact has happened. So in this case, the tribunal were persuaded that there was no issue at all with Mr. Price's performance. He'd worked perfectly effectively from home. And this is, I think, a difficult argument sometimes for employers. If somebody has worked 100% from home for a long period of time, it's going to be difficult, unless there's any obvious impact on performance, to justify a requirement when it comes to an adjustment, at least, to coming into the office on a full-time basis, or even, in this case, part-time basis. So key thing for employers, look to see whether you've got those objective business reasons. And secondly, look at what in fact has happened over a period of time if somebody's already been working 100% from home. So I mean, that's a relevant case, as I say, very fact specific, depending upon the requirements in relation to an individual's disability. And this is in the context, remember, of reasonable adjustments only. So it's not a general point in this case, but it's certainly of interest, I think, to most employers in that respect. So that's the first case of Price. Second case is Cairns against Royal Mail Group, which went all the way up to the Employment Appeal Tribunal. The claimant in this case, Mr. Cairns, was a delivery worker at the Hendon office of the Royal Mail, and he had a knee injury and osteoarthritis, which meant that he was unable to do outdoor duties because of this disability. So he was given a temporary role indoors, supernumerary role. They didn't need that role, but they gave it to him on a temporary basis. And then going through their ill health process, they dismissed him via the ill health retirement route in February 2018, because there were no other roles at that point, indoor roles, which he could do. He appealed against his dismissal, which was rejected in May 2018, and he brought claims in the Employment Tribunal for unfair dismissal, discrimination arising from disability, and a failure to make reasonable adjustments. The focus, particularly in relation to the reasonable adjustment claim, was that there was going to be a merger of his workplace, so the Hendon workplace, with another postal centre, and that was imminent. And so his argument primarily was the employer should have waited until this merger happened to see whether or not there might have been suitable alternative employment available indoors for me at that point. Tribunal dismissed all of those claims, and he appealed to the Employment Appeal Tribunal, who allowed the appeal. They said that the Employment Tribunal had failed to address some key aspects of Mr. Cairns' case, and those were, first of all, the imminence of the office merger. So this was happening, I think, within a month or two. It was possible that there might be a permanent role after the merger, and it was reasonable, potentially, or rather the tribunal should have considered whether it's reasonable, to employ him until the merger had happened. And so the case went back to the tribunal to consider. We don't have that judgment as yet, but the EAT said these were considerations. Tribunal should have properly considered these aspects of the claimant's case. So the key lesson take away from that is, if you're about to go through some sort of organisational change, if you're about to move offices or whatever it might be, there may well be an obligation in terms of reasonable adjustment to wait until that development's happened to see whether or not there might be suitable alternative employment. Now, when it goes back to the Employment Tribunal, of course, the tribunal might look at all these issues and still conclude that it wasn't a failure to make a reasonable adjustment. But I thought it was interesting because there are cases, of course, where you're about to make a change. And if you're in that position as an employer, it's at least a consideration that you might want to keep somebody on a temporary basis for a little while longer to see whatever comes out of the reorganisation. So that's Cairns. And then the final case on disability and reasonable adjustments is a case called Glasson against the Insolvency Service. This, again, was an Employment Appeal Tribunal in the end, decision rather. So this was a long-standing employee, applied for a promotion within the Insolvency Service, and the disability that the individual had was a stammer. So that was accepted to be a disability, of course, under the Equality Act because of the impact it had upon the individual. And because of COVID-19 restrictions, however, when he applied for the promotion, it was done over Microsoft Teams. Now, there was some consideration about what reasonable adjustments might need to be put in place prior to the interview. So the claimant said he needed more time to answer questions because of the stammer, but that was it. So he just said, I wanted more time in relation to the interview, and that was given. So the adjustment was made, the interview happened, he passed the interview, so he was appointable, but there was another candidate who scored higher, only by 1 point, but the other candidate scored higher. So Mr. Glasson was unsuccessful in this case. He pursued a tribunal claim on the basis that the employer had failed to make reasonable adjustments. And the basis for that was that his stammer meant that he'd not been able to fully answer the questions, as he was giving shorter answers to try and avoid the stammer coming in. So it wasn't that he needed longer, which was an adjustment that was given, but that he wasn't able to fully answer and was giving shorter answers to avoid the stammer. So the tribunal found that being interviewed live via a video conferencing route did put him at a substantial disadvantage because of his stammer. So that's step one. They did find, however, that the employer was not obliged to make reasonable adjustments because they didn't know, and nor could they have been expected to know, that this particular disadvantage was going to be suffered by the claimant. So just going back to the question of knowledge, which is always an issue in, well, very often an issue in disability cases, there are two things that the employer has to have knowledge of, either actual knowledge or deemed knowledge. In other words, we knew about this, or a reasonable employer should have known about this. And the two things are, A, that the individual has a disability, which clearly in this case they knew, but secondly, they must have some knowledge that the disability causes a substantial disadvantage. And this is where the tribunal accepted that the employer did not know that it caused a substantial disadvantage. The claimant hadn't raised this effect of his disability before or during the interview process. So he hadn't said, this is going to cause me to give shorter answers, which might mean I score lower. In addition to that, the tribunal noticed that the claimant had, and they noted rather, that the claimant had participated in interviews before, hadn't raised any concerns previously. And so they found that the interview process that the employer had adopted was objectively justified, so a discrimination claim arising from a disability failed, and also in relation to reasonable adjustments. And this went on to the Employment Appeal Tribunal, who upheld the tribunal's decision. So what can we take from that? Well, as I say, employers need to have knowledge not just of a disability, but also that there is a substantial disadvantage suffered by the employee. There is a proactive duty, as most of you are probably aware, in terms of reasonable adjustments. You as an employer have a proactive duty to make reasonable adjustments, but it was relevant in this case that the claimant hadn't drawn the employer's attention to his inability to expand on answers because of the stammer. And this goes to the point about knowledge. They weren't reasonably expected to have knowledge of the substantial disadvantage. Speculatively, but had the claimant been unable to answer the questions adequately on the day, bear in mind he passed the interview, but if he hadn't been able to answer the questions adequately on the day, it would have been sensible to make further inquiries about whether or not the disability had an impact upon his ability to perform. So it's important again to note that he passed the interview, so he did perfectly well from an employer's point of view, but he didn't do as well as the successful candidate. So just a few things to take from that. So those are the three cases I thought were interesting on disability discrimination and reasonable adjustments. As I say, I can't emphasize enough, every case is different, the disability is different, the extent to which somebody is going to be facing a substantial disadvantage is different, but there are some useful guidance. There's some useful guidance you can take from some of these cases. So that's the first section, and then the second section I wanted to look at is whistleblowing and protected disclosures, which is an area that's very commonly sent to us for advice. Employers often want to know more about whistleblowing and protected disclosures. So I picked out a couple of cases which I think are interesting in different respects. First case is McLennan against British Psychological Society, and this received a fair amount of press coverage in the HR press and generally. Dr. Nigel McLennan served as trustee and president-elect of the BPS. He was concerned about governance failings and reported to the Charity Commission and to others, which led to regulatory interventions in the BPS. and subsequently he was removed from his trustee position, which the BPS said had nothing to do with his whistleblowing and was for misconduct, but he claimed that it was a retaliatory act for his whistleblowing activities. Tribunal said that Dr. McLennan was not protected under the Employment Rights Act because he wasn't an employee and he wasn't a worker. So in order to have any protection under the current provisions, at least, you need to be either an employee or a worker. That was the tribunal decision. So it didn't get very far in the Employment Tribunal. And then he appealed to the EAT, the Employment Appeal Tribunal, and they concluded that the original tribunal had not adequately considered whether Dr. McLennan's role as a trustee could be analogous to that of a worker, particularly given his responsibilities and potential vulnerability to retaliation. So they accepted he wasn't a worker and they accepted he wasn't an employee. But in essence, they were saying, look, this kind of role is similar enough, potentially, and it's a consideration that the tribunal should have had before concluding that he didn't get protection. And in particular, they emphasised that denying whistleblowing protection to trustees might conflict with Article 10, freedom of expression of the European Convention on Human Rights. And the idea is you should be free to express, particularly in this context, any concerns you have about regulatory concerns or anything in relation to the charity. And therefore, there might be a conflict. Now, the EAT is not saying there is. They're saying it goes back to the tribunal to consider, but there might be a conflict with protection under Article 10. So they've sent it back to the tribunal for reconsideration with their guidance to assess the nature of his role and the applicability of whistleblowing protections. So this is the first part, probably, in a series of cases, I'd imagine, in relation to Dr. McLennan, but it does raise the bar a little bit in terms of who might be protected under the current whistleblowing regime. And that really is the thing to take away from this. This could have wider implications for other sectors, not just in relation to the charity sector, because he was a trustee and he was their president-elect. But you can see that there might be other roles that might be analogous to workers, and in particular, non-execs and volunteers. Those are the two which strike me as being potentially areas where somebody might argue that they are whistleblowing protected. And if you look at recent cases, there's two cases which I was very tempted to put in fact, for this session, but we have limits in terms of our timing. Two cases that are interesting. Groom is a case which is interesting where a volunteer was determined to be a worker and so therefore would have the protection. It wasn't a whistleblowing case, actually, but the provisions are the same in terms of what counts as a worker, and a volunteer was considered to be a worker, so would have protection under the whistleblowing provisions in that case. And then, of course, the Moon case, which some of you will be very familiar with, where an independent associate hospital manager was found to be a worker. So the tribunals generally have taken, in recent years at least, a slightly more generous view, a wider view to what might be a worker. But this case, the McLennan case, goes slightly further, of course, in saying even if you don't fit within one of those two categories, there is at least an argument that you're close enough in terms of your responsibilities to be protected. So watch this space, but it's clearly something that you should take into account. Now, certainly a lot of organisations already work on the basis that most people who come forward might be protected, and therefore they treat them accordingly, and that's very sensible. But there will be some developments, I think, over the next few years in this space. And then the second case was a case called Nicol against World Travel and Tourism Council and others. An interesting case. It may be fairly limited in terms of its applicability, but it is interesting. So this is a case in the private sector where the individual was employed as the Vice President of Communications and PR at this organisation. He'd worked there for a while as a contractor, as a consultant, but he started as an employee on the 1st of May 2019. And over a course of time, he alleged that the Chief Executive Officer in particular had made inappropriate comments, bullying and harassed staff, and had done all sorts of things in relation to employee well-being, and that he had made disclosures in relation to these inappropriate forms of behaviour. He was dismissed on the 14th of October 2019, officially for redundancy. Clearly, there had been a lot of dispute between him and his employer, but he was dismissed by reason of redundancy in October 2019, and then he filed claims for unfair dismissal and detriment due to making protected disclosures. So again, it's a whistleblowing argument. Tribunal decision was that not all of the disclosures were in fact protected, and this is a common theme. If somebody says they're a whistleblower, very often the tribunal will conclude some disclosures are protected and some are not. But in this case, they accepted that one was a protected disclosure because he'd sent an email to two external HR consultants who were working with the employer to say these are inappropriate behaviours from the chief exec. But crucially, and this is the core of this case, that email, the contents of that email, was not communicated fully to decision makers. And the tribunal said that the dismissal, therefore, was not due to him making protected disclosures, but was really due to a breakdown in relationship. So they didn't buy the redundancy argument. They didn't accept that there was a redundancy, but they did accept that there had been a breakdown in relationships, not due to him making protected disclosures. And therefore, the dismissal was fair and not an automatically unfair dismissal because of his whistleblowing. Well, he appealed to the Employment Appeal Tribunal, and they allowed the appeal in part, focusing mainly on errors, procedural errors, and the assessment of certain disclosures by the tribunal. In one case, for example, there was a disclosure which had been admitted by the employer, but the tribunal, on its own mind, had rejected that it was a protected disclosure. But crucially, they did accept that the dismissal had not been due to the claimant making protected disclosures. The key issue in all of this is the knowledge of the decision maker. So the EAT agreed with the tribunal that it's not enough to know that somebody has made disclosures. You need to have knowledge of the content of a protected disclosure in order for the employer to be liable. And I can see that that makes a degree of sense. So in this case, the decision makers knew that there'd been emails. They knew broadly, that he'd been raising issues of concern, but what they didn't know was the content. And so this decision, the AT saying, look, you have to at least be aware of what's in the communication before it can have an impact on your decision about dismissal or not. Now, the reason I said at the beginning is it might have limited effect for most employers is because in many cases, I mean, if you put yourself in the position of an employer who's facing a challenge by the employee in either redundancy, disciplinary or whatever case, the likelihood is the employee is going to draw to the panel's attention the fact that they've raised disclosures and is very likely to give them copies of what in fact has been disclosed. So I think this is unusual in that sense because the decision makers didn't have access to the information, and most employees, frankly, were going to bring it to the attention of a panel if they think there's a link between the two. But it is interesting because, again, it goes back to what's required for the purposes of an effective disclosure. So that's nickel. Those are the two whistleblowing cases that I thought were interesting in 2024. And then finally, I wanted to look at the Equality Act and belief discrimination and a few cases that bring out different points of interest, I think. So case number one, Alison Bailey against Stonewall Equality Limited and others. This again has received a fair amount of press coverage. This is Alison Bailey, who has gender critical beliefs about sex and gender identity. And she's also a barrister and member of Garden Court Chambers, so barristers' chambers. She came out publicly, I think, on Twitter to criticise Stonewall's stance on gender self-identity and a few other things. And that led to complaints from other members of her chambers in relation to her social media activity. Garden Court Chambers investigated and they upheld parts of those complaints against Alison Bailey. And then after the investigation had already started, Stonewall complained to the chambers about her tweets. And Garden Court Chambers had taken the slightly unusual step, I suppose, of publicly tweeting that they were investigating her tweets and that she did not represent the views of the chambers. But there was a complaint then from Stonewall. So there's been a number of hearings on this, and in relation to the Garden Court Chambers action, the tribunal found that they had directly discriminated against Alison Bailey due to her gender critical beliefs. And in particular, there were two acts of discrimination by the chambers. One was the public tweet about investigating her comments. So they came out publicly and said, we are investigating her and her comments do not represent the views of the chambers. That was before the end of the investigation. That was right at the start. And then secondly, the outcome of that complaint, because they took the view that she had not complied with core elements of her bar requirements. So they lost, so the Chambers lost in relation to the discrimination claim. But the more recent complaint is in relation to the involvement of Stonewall. And this is where it's interesting from an employment lawyer's and an HR point of view, because she was relying upon Section 111 of the Equality Act, which is in relation to causing or inducing contraventions of the Equality Act. So this is not directly taking action that's discriminatory, but it's inducing or causing action which is discriminatory. And we do occasionally see cases on this basis. And so, you know, if you're I don't know, in the healthcare arena, I suppose if you're an ICB or something like that, and you are suggesting action that might be taken by a trust, there is certainly the possibility of this action, this section being relevant. Again, any situation where you've got a third party influencing or attempting to influence an outcome might kick in Section 111. But the tribunal dismissed the claim against Stonewall for causing and inducing discrimination. And then it went to the Employment Appeal Tribunal, who are also upheld that dismissal of the complaint against Stonewall. And there are a few key points that came out of the judgment. The first is that Stonewall's complaint was, in the words of the Employment Appeal Tribunal, just a protest. They weren't trying to induce discrimination by the barristers' chambers. They were protesting about the things that they'd seen. And the fact that the chambers then reacted in a certain way wasn't reasonably foreseeable by Stonewall. The responsibility for the discrimination lay squarely with Garden Court chambers. And so in relation to Section 111 of the Equality Act, which as I say covers instructing, causing or inducing, they looked at the various elements of that and they said, look, causing, you don't have to have any particular intention. It's a question of fact. Did this cause this to happen? And is it fair and reasonable to hold that party liable for causation? But inducing does require an intention to persuade. So if you're inducing a party to discriminate, you need that intention to persuade. So just going back before I finish. So I think it's interesting, as I say, in relation to those cases where you have got third party intervention, the test is reasonably high in terms of Section 111 and what that might amount to. So this is secondary case consideration, but it is something which is relevant to in some cases. So that's Bailey. And then the second case is a case called Amuba against Michael Garrett Associates Limited. This was a theatrical case. So the claimant, Miss Amuba, was a Christian actor and was cast initially in the role of a lesbian character, Celie, in the theatre production of The Colour Purple in early 2019. Once it was announced that she was going to play this role, there was a backlash because somebody had found a past Facebook post sometime before where she had expressed her belief that homosexuality was a sin. And the charge that was made against her in social media was that she was a hypocrite to be playing a lesbian character. That was the allegation. And it led to a little bit of a media storm, social media storm, with the tweets. I think it was either originally from or retweeted from an actor who'd played a character in Hamilton. And so it became quite a widely publicised point on social media. And that led to the termination of both her contract with the theatre and also with her theatrical agency. That led her, after that, to happen to claim direct religion or belief discrimination, harassment, and breach of contract. So she brought claims on that basis. You might think ill-advisedly, but just before the tribunal hearing, she then read the script. So at this point, when she was complaining, she hadn't actually read the script. And having then read the script just before the tribunal hearing, she volunteered that she wouldn't have, in fact, ever played the role. And she would have resigned anyway, because once she'd realised it was a lesbian character, she clearly hadn't when she accepted the role, she wouldn't have accepted in any event. And the tribunal did not uphold her case and also ordered very significant costs against her in terms of a cost assessment. But the main thing is that they found her belief was not the reason for her dismissal or the agency contract termination. It wasn't that. That wasn't what caused the dismissal or the termination. It was the commercial risk to the business, which was in the minds of the decision makers at that point of decision. So that was their focus, and therefore it wasn't discriminatory. She appealed to the Employment Appeal Tribunal, and the Employment Appeal Tribunal said that the decision was, they agreed with the tribunal, that the decision to bring her contracts to an end those decisions were separable from her beliefs. And it's worthy of consideration, this judgment, because it looks at some of the previous judgments in this case and sets out some guidelines. So the existing law is that it must be it's sufficient to have a protected characteristic having a significant influence on a decision, whatever that decision is. Doesn't have to be the main reason in order for discrimination to occur, but it has to have a significant influence on the reason why the employer's made that decision. It has to be part of that decision making. It's not enough for it just to be the context, case called Ahmed. And what the tribunals have to do is they have to exercise critical judgment. They have to look, in the words of the EAT, with a critical eye to assess whether the seemingly innocent reason given by an employer stands up to scrutiny. And you need to separate the context in which a decision is made from the reason the decision is made in this case. And in this case, they accepted that it was the commercial risk that led to the termination, and the fact that she had these beliefs, these Christian beliefs, was just context. It wasn't the reason behind the decision to dismiss. Now, this is interesting, and I think it's an area that we're going to see more developments in. There's another case which I was tempted to put in but haven't, which is going to the Supreme Court, I think, very shortly, which is a case called Higgs against Farmers School. In fact, it's just gone, although we don't have the outcome of the Court of Appeal. I think there's a similar point there, because that's a dismissal of somebody working in a school where she'd expressed concerns about sex education. I think this is going to be one of those decisions that is going to be interesting for the future. It's not going to go any further. Mr. Muba was not granted permission to appeal to the Court of Appeal, but I think it's an issue that's going to come back to be considered in more detail. I think from an employer's point of view, it's a useful case, because you can make the argument relying upon this that actually if there is a commercial risk to your organisation, that can be the reason for the termination. But I think it's not without risk, because you have to come back to, in essence, why was there a social media storm? Why was there a risk to the business? And that was because she'd expressed her own in this case, religious views in social media. So I'm not sure it's without problems, this case, but it is a helpful case where you are balancing the needs of different protected characteristics within the workplace. It's a useful case to go back to. Let's see what happens when the Higgs and Farmers School case progresses. That's also worth watching. And then the next case is Turner Robson and others against Thames Valley Police. Got a couple of cases left before we have time for questions. This is an interesting case from a different perspective. So 3 white British police officers brought claims of direct race discrimination against Thames Valley Police Force. What had happened is that the force had implemented what they described as a positive action progression scheme, PAPS, and they had given a role to an Asian sergeant, Sergeant Sidhu, without a competitive process. So a vacant detective inspector role had been offered to her without competitive process. Hadn't been advertised. Claimants had not been given the opportunity to apply, and the tribunal looked at this case. They challenged it on the basis of discrimination, and they concluded that the claims of direct race discrimination were indeed well founded. So some relevant points to take out of that, because many of you on this discussion will have positive action that you're considering or you have taken in relation to discrimination and trying to remove or eliminate discrimination in your workplace. So it is an interesting area. But in this case, as I say, the tribunal concluded that the actions of the employer were actually positive discrimination, not positive action. And the relevant provision is section 159 of the Equality Act, which is in relation to recruitment and promotion. Where they failed was that they'd failed to demonstrate proportionality in achieving a legitimate aim. So the legitimate aim of encouraging a more diverse workforce, of course, was it reasonable and perfectly acceptable, but the way in which they'd gone about trying to achieve that, in the views of the tribunal, was not proportionate. And some of the key things that were relevant in this case, a lack of competitive process clearly disadvantaged non-BAME officers. They were obviously disadvantaged. They just couldn't have applied for this process. There hadn't been an equality impact assessment. And as is, I suppose, something which often happens in organisations, there was a clear directive to make it happen without proper consideration of implications. And I think that is something to watch out for. If there is a legitimate desire to become a more diverse workforce, of course that's reasonable, but you've got to think through how you're going to achieve that and whether or not it's proportionate. So a few lessons to be taken from that. If you're going to have a process, you want to make sure for the most part that it's transparent and competitive. You want to make sure that you've got an equality impact assessment if you're going to try and rely upon Section 159. Need to make sure that there is regular equality and diversity training for senior managers. That's a general point, but particularly in relation to when it comes to considering positive action. And then finally, and this is the crucial thing, think about proportionality. Are there other steps that we could take which are less discriminatory? Because on the face of it, obviously, this is discriminatory in relation to, in this case, white officers. Is there another step that we could take which would achieve the same objective but in a less discriminatory fashion? And finally, so this is a case again in relation to beliefs. I just want to talk about this case because again it's been in the news fairly recently, and it's interesting because you're back to this issue of balancing different protected characteristics, and in this case particularly in relation to beliefs. So Mr. Thomas was engaged as a consultant for this NHS trust, and he had his assignment terminated after 3 months. The employer said, completely unrelated to anything other than he'd got an undisclosed unspent conviction, which he hadn't mentioned when we had recruited him. He said the real reason wasn't that. The real reason was because he'd expressed his belief in what he described as English nationalism. And those beliefs included anti-Islamic views, for example, the forcible deportation of Muslims. That was part of his set of. He said, therefore, that he'd been discriminated on the basis of his political or philosophical beliefs in that way. Tribunal looked at this, and the first consideration in all these cases is whether or not those beliefs are in fact protected, and they concluded that his beliefs were not protected under the Equality Act 2010. And in lawyer speak, and I'll come on to what that means in a moment, but he'd failed what we describe as the Granger test. So he'd failed the fifth element of the Granger criteria. So the case of Granger sets out a number of things when tribunals are assessing whether or not somebody's beliefs are protected, sets out a number of criteria that have to be boxes that have to be ticked. And in this case, the fifth criteria was one where he failed because the tribunal concluded that his beliefs were not worthy of respect in a democratic society. And that is the fifth criteria. So I thought it was worth just talking about some of the key decisions that are referred to in this case, because it does give more of a framework for employers when assessing whether or not a belief is protected. So as I mentioned, Granger is the leading case. Granger against Nicholson goes back a long time now, 2010. But those 5 criteria have been well trodden by the tribunals over the years. And there's been a lot of focus on this fifth criterion, that the belief must be worthy of respect in a democratic society. The Marie Forstater case set a high threshold for this level of consideration of beliefs, with the Employment Appeal Tribunal saying, look, the only things that you would exclude are beliefs which are akin to Nazism or totalitarianism. So it's a high bar. If you've got a series of beliefs and you pass all the other criteria about how they're solidly held and all the rest of it, then it's a difficult argument to say that your beliefs shouldn't have protection unless they're akin to Nazism or totalitarianism. And there's a couple of other cases mentioned, in particular Norwood, where this was a completely different sort of case. It was an individual who put up posters that were anti-Muslim, and she was not protected by Article 10 of the European Convention on Human Rights. So she didn't get protection in the same way that Mr. Thomas hadn't had protection. And the reason for that is Article 17 for the most part, which is a balancing exercise. And so in effect, you can have your beliefs, of course, but if your beliefs are, as you can see, they're incompatible with the beliefs of others. So if you're engaging activity which is aimed at destroying or any of the other rights of freedoms of other individuals, then that's not protected. So it is that balancing exercise between having the rights to express your views and expressing them in a way that would be detrimental to others' rights under the European Convention. So the EAT dismissed the appeal. They said the tribunal had been quite right in finding that his beliefs were not protected. And their reasoning was, look at the beliefs that he's expressed. He had a belief in the forcible removal of Muslims. That's incompatible with other convention rights, very similar to the case of Norwood, and it fell within the Article 17 prohibition. So what do you take from that? Well, it's a reminder that there is a high threshold for excluding beliefs from protection, but it's not an impossible threshold. And in this case, particularly focusing on his anti-Islamic views involving forcible deportation, he didn't receive the protection that he was seeking. And you've got to be able to assess in the workplace whether or not it's reasonable to hold those beliefs and express them in those ways. So it is always a balancing act. And I mean, certainly in recent years, the gender critical side of the argument has been successful with Forstater and other cases, and the Bailey case is another example. Less successful for these kind of beliefs. And I think we'll see more of these cases going forward. But it is, again, a reminder to employers that not all these beliefs are going to be protected. It depends upon whether or not they are the sort of beliefs that are able to be held in a democratic society. So that's the end of the form presentation. And so we've got about 15 minutes left. We're running for an hour for any questions that anybody has about these cases.
Thank you, Andrew. That was really, really helpful. I was just thinking particularly on the Amuba versus Michael Garrett case, the actress who was terminated from her role. The finding in that kind of hinged on the potential of commercial impact to the business. If that hadn't been in a commercial setting, so a sort of similar case, but perhaps in public sector or charitable sector, do you think it would have gone to the Granger principles in the way that you then discussed? I just I'm interested in how that balance would sort of play out in as a more public setting.
Yeah, so I mean, so clearly in this case, there was a commercial aspect to it, and that was a key thing. I think if you look at other cases, I'm thinking in particular in relation to a case called Page, where the NHS Trust in that case was able to show that the way in which beliefs had been expressed could have had a potentially serious impact upon their organisation, which wasn't commercial in the sense of financial, but it was in the sense of, so Mr. Page expressed beliefs about same-sex adoption, and the NHS Trust was able to argue, I think it was Medway, but they were able to argue successfully that there was a risk, because he was a very public-facing party, he was a non-exec director, because he was very public, expressing those views could dissuade people from the LGBTQ plus community from coming forward because of the way in which he was saying these things in public. So it's not just financial considerations. I think you could easily see in a public sector organisation somebody expressing these beliefs in a very public way could well lead to significant disadvantage that are not financial. So yeah, but you just have to be able to show as an employer that there is either an impact or very likely to be that kind of substantial impact in order to make that kind of argument. But yeah, so I can foresee that you would make that in the public sector as well. It's a slightly different argument, but it's still there. Yeah.
Yeah, really helpful. Thank you so much.
How do we assess the reasonableness between two employees who hold strong religion versus another employee who holds LGBT beliefs?
Yeah, it's a very interesting question. I think if you go right the way back to the sort of advent of the Equality Act, there was a view expressed in some of the cases that there wasn't really much of a conflict at all and that it was all easy to deal with. I think the courts have accepted over the years that really isn't the case for most employers, and that very often you will have these disputes and disagreements in the workplace that you need to manage. The cases very much focus on the manner in which you express views as well as the views themselves. And so, again, you know, if somebody, there's a case called Smith against Trafford Housing Association, where an individual expressed disagreement with single-sex marriage, same-sex marriage rather, and he expressed his disagreement in a very respectful way. The tribunal concluded, the High Court rather concluded, and so it was unreasonable for the employer to take action on that basis. And there are other cases where, you know, the way in which views are expressed is not in itself offensive because of the manner in which you do that. So when it comes back to that balancing act, I think the thing that comes out very clearly is it's if you have a protected belief, that's a protected belief. The way in which you express that is the key factor. So if you come in and you express your views very forcefully and unnecessarily and in an extreme way, then in terms of that balancing act, it may well be appropriate to take action against that employee. But simply holding the beliefs, and if you look at gender critical beliefs, the same is true there. Simply holding those beliefs is not necessarily a problem, even if your colleagues don't like them and they are offended by them. It's all about the expression and the way in which the individuals express those, either in the workplace or outside, depending upon the context. So it is a difficult balancing act, but as I say, there's a very high threshold for beliefs, and so if people have very strongly held views, taking action on the basis of their beliefs is going to be discriminatory, but it may be acceptable if the reason you're doing that is the way in which they're expressing them or the impact it has upon your organisation, which is really going back to the Amuba case.
If an internal candidate's job offer is withdrawn for sickness levels and they then state they have an underlying health condition that meets the Equalities Act, although their sickness was not related, they have not declared any disability for the recruitment process and not claimed guaranteed interview, would it be reasonable to withdraw the offer based on high service needs and vulnerable clients?
Well, I mean, just taking that apart a little bit, I mean, there's no obligation on an employee to declare their disability during a recruitment process. You would want them to, because you'd want to make sure that you're making reasonable adjustments, but they're not required to. And they're not required to go through the guaranteed interview scheme either. So if you become aware, once you become aware, then you've got the obligation to potentially make reasonable adjustments and also not to discriminate. So the focus very much is on being able to evidence why you have to withdraw this offer and the impact that the disability is going to have on, as you say, high service needs and vulnerable clients. I mean, in my experience, you have to, as an HR person, you have to push back on that. Sometimes managers will say, oh, it's very difficult. We now know about this sickness absence. We now know about these issues. And it's impossible for the individual to work in this sector, in this area. I'd always push back and be a critical friend and see whether that in fact is the case. And also to make sure you've got up-to-date medical information and a view from occupational health. We've had cases where, you know, there has been serious sickness absence, there's been a disability, but actually for a variety of reasons, once you've dug deeper and once you've had a proper occupational health assessment, the concerns either disappear or are significantly reduced. So tread very carefully in that situation, understand what the disability is, get as much information as you can, ideally from occupational health, and assess whether or not realistically there's anything you can do to make an adjustment to allow them to continue in that role, or rather to take it up, because we're talking about an offer in this case.
Hello, me again. Is there anything, Andrew, that you think particularly useful to keep a bit of an eye on in the coming, say, 6 months? I know you pointed to a few watch this space examples in your presentation, but is there anything else that you think would be beneficial for employers to keep watch of?
I mean, outside of the field of case law, the big thing, of course, is the government's plans. So keep an eye on that. The consultation is going to kick in relation to lots of government proposals, and we've done a webinar on that. We're doing more work on that, so watch this space for that, because I think that more than any case law is going to make the biggest impact over the next couple of years. But in terms of cases, now, I mean, I think we're going to see a lot more. Watch out for the Higgs case. I mentioned that already. Then we're going to see a lot more about the conflicts between protected characteristics. I think that's certainly the case. And I also think, as I mentioned earlier on, we'll see an expansion of protection. The really big issue that may or may not get resolved or get changed in the course of this government is whether or not the distinction between employee and worker is going to disappear. At the moment, it's some way off because the government haven't got concrete plans in this respect. But all these kind of questions about, you know, is somebody a worker, are they protected, would disappear if we have one category, which is both employee and worker. So not really, but the way to keep ahead of these things, Sarah, you've helped me enormously, because the way to keep informed and the way to keep up to date with all these things is subscribe to our email newsletter and also on social media. So I've put my right at the end of the slides, you'll see our links. So follow us on LinkedIn, Twitter, and all that kind of stuff, and you'll be kept up to speed with all those sorts of things. So thank you very much for teaming me up in that helpful way.